I'm told that the defense counsel is looking at that. The specific term that the U.S. attorney used is that it was privileged under Section 6103. I'm not a lawyer, and I don't know what that means, but all we can do is hope that Mr. Olafson's attorneys take a look and find out if, because 6103, when I read it, had to do with tax returns. This wasn't a tax return. This was a safety recall notice and a mandatory recall at that.
So it's possible that the ATF misled the court.
Oh, it's very possible. In the owner of the NFA weapon, the ATF claims they don't have to tell the judge because an NFA weapon has an excise tax attached to it. Therefore, tax privilege prevents the judge from knowing that at the same time we're indicting this guy. We're telling this guy it's not a machine gun. And the judge was prevented from seeing that. I don't blame the judge at all, but he had no way of knowing this information unless the government produced it. And they just said, well, we don't see where this is exculpatory, and we claim it's privileged tax information. As a matter of fact, the entire discovery they claimed was privileged tax information under 6103. And these were documents that were known to exist. We asked for an open letter to the industry. They claimed that was tax privileged. It just disgusted me. They were able to prevent the judge from knowing the other side of the coin right out of the box.
This is Talking to America. Our special guest today is Len Savage. We're talking about the U.S. versus Olafson case, which will affect everybody who owns a semi-automatic firearm or even some other types of guns. And so, Len, I think if you'd carry on, please, I'd appreciate it.
Sure. So we've got a situation where the ATF has got a 50% error rate on their classification of this man's evidence. It goes to court. He appeals to the court and says, the ATF has documents that prove that I'm innocent, Your Honor, and they won't give them. Could you please compel the government to turn over the documents that prove my innocence? And the ATF claims to the court that it's privileged tax information, and the judge is prohibited by law from viewing it. You'll just have to take our word, and no, we're not going to show it to anybody. This was just Monday morning. This is before the trial even started.
Okay, well, going from there, you said that during the courtroom time, if I can put it that way, that the ATF actually displayed a video that they made of the test firing of this firearm?
Yes, they did. Isn't it amazing, given the Fairness in Firearms Testing Act and their refusal to adopt it, that when it's in the government's best interest, they know, the ATF knows how to operate a video camera and obviously must have one. Because they gave a very edited 15-second video of the gun malfunctioning. An M16 has a fire rate of approximately 800 rounds a minute. This gun was firing at a far faster rate, and that's indicative of a malfunction alone. It was untimed fire because the firearm in question didn't contain an auto-sear, didn't have the provision for an auto-sear. I was finally allowed to examine it. Now, imagine having an expert who's told, your expert can't touch the weapon, and we're not going to let him look at it, and we're not going to allow him to shoot it. And even though we made a video, we're not even going to give your attorney a copy of the video prior to your trial because we're afraid of what will happen to the video. And if I'm going to quote right, they were afraid that the video would end up in a documentary, was what I was told.
Before we come back to this video, where you showed how their tester was firing the gun for fear of his life, what did they have to say about the gang? I think that's the alleged documentary, to quote them, and JPFO in general. Well, yeah, we're jumping ahead a little bit, but the ATF and the government decided to challenge my expertise in firearms. They claimed, among other things, let's see, they claimed to the court that I intentionally tried to mislead the court by falsifying my resume to the court. They said that I really wasn't qualified as an expert on machine guns, and they said that I shouldn't be allowed to testify about this particular firearm because I never fired it. And they also told the court that I had a personal vendetta against the ATF. It's amazing because they didn't want me there because I was going to provide wholesale attack against the ATF, yet I didn't say a disparaging word against the organization other than the fact that they don't have any written testing standards and that I disagreed with some of the management practices
but it was them who attacked me. They went on to bring up your organization, Aaron, and told the court that I was associated with you. Now, remember, this is a Daubert hearing. This is supposed to have to do with my expertise in firearms. But the ATF chose to bring up to the court that I shouldn't be an expert because I associate with you in JPFO, a Jewish civil rights organization. The judge did see through this and ended up asking the U.S. attorney, just what in the heck did that have to do with expertise in firearms? And he roughly shot him down on this, but I'm more than a little upset. Would they have a problem if I was associated with the NAACP? I don't know what they were getting at, but I didn't like it.
Okay, well, going back to this testing then, as far as the edited video, can you elaborate on that?
Yeah, well, not only was the gun obviously malfunctioning, but the person from ATF who was chosen to shoot this particular firearm was so afraid of catastrophic failure, he was holding the firearm as far out in front of his body as possible and wasn't shouldering the weapon like one would normally shoulder a rifle. I think he feared that he was going to be wearing a bolt carrier for an eye patch if the test went wrong. But I guess if the test went wrong, we wouldn't have seen the video. Now, it was very telling that even they realized that that this rifle was of just as much risk to the shooter as it was if it was pointed at somebody, and that obviously wasn't a machine gun. It was a gun that could fly apart at any second. What it means is that if the ATF can manipulate the court system and can prevent evidence that proves your innocence from being brought forth at your trial, I'd say that's pretty significant, wouldn't you? I specifically asked this U.S. attorney, trying to clarify what he was saying. I asked him, are you saying if I take my granddaddy's double barrel out hunting and I pull one trigger and both go off because it fires more than once per function of the trigger, that's a machine gun? And he acknowledged it. People better wake up. This isn't just about semi-automatic firearms anymore. You duck hunters who look down on the guys who own the black rifles, you're clearly marked as next. A double-barrel shotgun malfunction is now a machine gun. The ATF, through the U.S. attorney, made the argument and nullified my testimony that showed that it was a malfunction, that it doesn't matter. Even if Mr. Savage is correct, it doesn't matter because the law states any weapon which shoots. And since it doesn't specifically exempt a malfunction, you must be guilty. If they meant to exempt malfunction, they'd have put it in the law. And jury's given this kind of skewed, neutered view of the definition of this particular firearm within the law, which would be Chapter 26, United States Code, Section 5845, Paragraph B. This is the definition of a machine gun. And because in that definition of a machine gun, a malfunction is not exempted. They don't enumerate it. It was taken for granted. But the ATF has seized upon the situation that since it was not specifically exempted, then it's illegal.